But when it comes to polity, usually students are highly confused whether static would be covered or current would be covered. So in this video, what we are trying to do is, we are trying to cover the most important topics of polity, whatsoever has happened in past 1 year, we would be covering that. This is the first condition, detention should be illegal and unlawful. Every arrest is custody, but not every custody is held for arrest. Problem is, there can be a statement, every arrest is custody, but not every custody is arrest. Let us say the government in the current income tax bill 2025 has said that we are free to keep a surveillance on your digital media if we think or we believe or the income tax department believe the person has siphoned off the tax liabilities, like the way Amitabh Bachchan, the way Jackie Shroff says. So that cannot be used by any other person for the profit purpose. Samsung industry workers have come up with a right, or they have demanded that they should be allowed to form the trade unions. Hello everyone, this is me Kapil Sikka. I welcome you all to PW UPSC Wala English. As you know, in prelims, we require a lot of current affairs. But when it comes to polity, usually students are highly confused whether static would be covered or current would be covered. If we want to cover current, how it should be covered, and what topics are important and what are not very important. So in this video, what we are trying to do is, we are trying to cover the most important topics of polity, whatsoever has happened in past 1 year, we would be covering that. Apart from that, my effort would be to link it with the static section as well. As and when I would be covering the current point, what has happened, I would also be covering the static section of that very particular area. So for today, the topic is fundamental rights, DPSPs and fundamental duties. We just need to see what has happened with regard to the current or with regard to fundamental rights in current affairs. First news is from the High Court, where the Delhi High Court has recently ruled that foreigners cannot claim the right to reside in India under Article 19(1)(e). So we need to quickly recap Article number 19. What Article number 19 talks about? Article number 19 is first thing given to the citizens only. Citizens can claim this very right. So this makes very clear that anyone who's not a citizen cannot claim this right. Why? Because it gives us freedom of speech and expression. It gives us freedom of movement, freedom to reside, freedom to trade, practice profession, practice trade, as well as freedom of association, as well as freedom of cooperatives. So these rights are only given to the citizens, and you also know that Article 19 happens to be the most fragile fundamental right. Most fragile fundamental right means because it has the highest forms of restrictions. If you will see Article 19 clause 2 till 19 clause 6, you have a list of restrictions. Speech and expression has restriction. Then you have movement has restriction. Then you have the freedom to settle has restriction. Freedom to trade has restriction. Let us quickly recap what restrictions we have. 19(1)(a) talks about freedom of speech and expression. Restrictions are that with regard to unity, integrity of India, with regard to sovereignty of India, with regard to friendly relations, with regard to decency, morality, contempt of court, defamation, in all this scenario, your freedom of speech and expression can be curbed. This is first restriction. Then comes, do we have freedom of movement, freedom to reside in 19(1)(d), 19(1)(e)? Yes, that freedom also comes with the restriction. You cannot settle in a scheduled tribe area, or your movement can be curbed in public interest. So this is where we have a restriction. Then you have right to form cooperative. Then you have right to form associations can be restricted on the element of the security of state. So this is where we have a lot many restrictions. 19(1)(f) talks about freedom of profession can be restricted. Number 1, where you need a specialized degree. Number 2, if that particular sector is nationalized or government is trying to establish a monopoly of one particular institution. So this is how there are a lot of restrictions. The right with highest form of restriction is Article number 19, only available to the citizens, would be automatically suspended during emergency. Fine. Now let us go to the news again. 19(1)(e) of the Constitution. Foreigners do not have this right. Now why writ petition was moved by a suspected Bangladeshi national claiming his detention as illegal and without authority. Now, first thing, we also know that when it comes to the other rights which are available to persons, in that scenario also, persons are the aliens, but they have to be friendly aliens. Let us say today we do not have good relations with Bangladesh. Let us say, for example, so Bangladeshi citizen would be enemy alien. Though currently the person is friendly alien, but he is a person and Article 19 doesn't apply on him. Number one. Number two, he is talking about detention. When it comes to the detention laws do not cover the protection to the persons as well. In most of the cases, in detention laws, non-citizens are not covered. So what he's saying, I want to move to the court. I want to implement a habeas corpus. I want that court should implement a habeas corpus and ensure my release. Though that can be available, from where it can be available from article number 21. Why? Because 21 talks about personal liberty, and that is for person, everyone, anyone who is in the country can claim that right. But at the same time, if you could recall article number 22 clause 3, it says that in case of preventive detention, the parliament can make laws with regard to and regulation of preventive detention. Now, this person has got the habeas corpus. He went to the court for habeas corpus to be issued. So, this is where we would be discussing what is habeas corpus. Meanwhile, let us discuss what fundamental rights are available to all. Article number 14, equality before law, equal protection of law, available to all. Article number 17, untouchability, available to all. Article number 18, abolition of titles, ensuring equality, available to all. Article number 20, protection against offense. Article number 21, 22, 23, 24, available to all. Right to primary education. Then Article 23, prohibition of human trafficking and forced labor, available to all. Article number 24, prohibition of child labor in factories, available to all. Freedom of religion, propagation, profess the religion, available to all. Similarly, 27, right not to pay taxes or no taxes on religious work, available to all. 26, where you have right to regulate and practice religion as per your own choice, and where you have the right to manage your religious affairs, available to all. Similarly, 28, freedom from religious instructions in any education institution funded by the state, available to all. Got this? Then rights which are only available to citizens, Article 15, no discrimination, Article 16, public employment, Article 19, freedom of speech and expression or freedom of speech, expression, movement, Article number 29, right to minorities, and Article number 30, right to linguistic and religious minority to establish their institutions. So these articles are available only to the, not available to the foreigners or only to the citizens, only to the citizens. Now let us discuss the another static part, habeas corpus. What is habeas corpus? Habeas corpus is a Latin maxim which says, let us have the body. If anyone is under detention. Now what is detention? Detention can be of two types. Detention can be a punitive detention, where a person is lodged in jail as a punishment once either the trial is going on or he has been convicted. Either he is an accused or he is in convicted position, he is put in jail. That is called as punitive detention. But in a preemptive manner, when we know the offense might happen, the person has capacity to do the offense, in that scenario he is detained in a preventive manner. That is called as preventive detention. Fine. Now habeas corpus applies to the detentions either in preventive manner or in punitive manner, but detention should be illegal and unlawful. This is the first condition. Detention should be illegal and unlawful. If the detention is legal and lawful, the court will not interfere. Court will not issue the writ of habeas corpus. This writ can be enjoyed through article number 32 as well as article number 226. Article number 226. Apart from this, this writ can be filed by the person who is aggrieved the person who has been detained or by any other person on his behalf. So this writ can be filed by the person detained or any other person on his behalf. So this is where the concept of res judicata comes, that another person on the behalf can file. Same goes with the locus standi, where a person who is not involved, who is not responsible, can file this. Now it is an order issued by the court to a person detained another person who has detained another person to produce the latest body before it. The writ habeas corpus can be issued against both public authorities and private authorities. Obviously, the government institutions, the jails, the police, or me as well. I am a private person. If I detain someone, habeas corpus can be issued for me as well. Now, on the other hand, it is not issued when the detention is lawful. This we have already discussed. And the proceeding is the contempt of legislature, or the detention is by the competent authority. When the is for contempt of legislature, a person has been detained for the contempt of legislature. How does that happen? Under Article 105, under Article 194, if you defame, if you try to lower down the image of the parliament, so they have a privilege, parliamentary privileges. If a person has been detained under parliamentary privileges, habeas corpus cannot be issued. At the same time, when the detention is by the competent court, when court has ordered your detention, that means a legal lawful detention, you cannot go with habeas corpus. Detention is outside the jurisdiction. In that scenario also, let us say the High Court of Patna cannot issue a habeas corpus for a person who is detained in the Tamil Nadu. So for that, you need to go to the High Court of Tamil Nadu, which has the jurisdiction upon the case. So when the detention is outside the jurisdiction of the court, the person cannot get the habeas corpus by another or by that court. Next right is right to be free from adverse effects of climate change. It has been given as a right under article number 21. Life means to live with dignity. If you could recall the environmental cases in the country, MC Mehta, oleum gas leak case, then the Green Bench case. So these cases, Vellore Citizen Forum case. So these cases time and again have established that right to life also means right to clean air, clean water, right to clean environment. And this is where the court has now come up with a new right to be free from adverse effects of climate change. So they have said that right to be free from climate change is basically, it should be a fundamental right. Now this was with regard to the protection of two critically endangered bird species. This you can do in your environment as well. Now both are the scheduled species and they have to be protected. Article 21 and 14 are important sources of right to clean environment. This we have already discussed. Clean environment where equality has to be practiced. Everyone should be given the same environment. Everyone should be treated equally with regard to the protection from the climate change. That is why 14 and 21 means expansion of right. Fine. So this is not right to health. Now next is right to health. Next is right to health. So this would be this is right to environment. Next would be right to health. Now when it comes to what DPSPs do we have for the protection of environment, Indira Gandhi by 42nd Amendment has introduced 48 capital A. This talks about that state is duty bound, okay, or shall endeavor to protect and improve the environment and safeguard the forest and wildlife of the country. It also places an obligation on the state to protect the environment and life, okay, wildlife. Next comes fundamental duties. At the same time, 15(1)(g) says that it shall be duty of the citizen to protect their environment. Every citizen should protect and improve the natural environment, including forests, lakes, and should have compassion for the living creatures or living beings. Okay, so this is a duty. So right to life as a right to environment as a fundamental right. Right against climate change is a fundamental right under Article 21. At the same time, right given under DPSP 48A and 51G as a fundamental duty. Next news was about custodial death. Now what exactly is custodial death? Now for custodial death, at one point of time in DK Basu case, Supreme Court held that custodial death is against article number 21. Why custodial death is against article 21? Because custody is something where the police or the jail authorities should ensure your protection. If you are or any person is being killed within the protection territory, that means the police or the jail has failed to do their duty. And that is why court came up with the 10 commandments of the arrest as well as of the custody, where the arrest has to be done legally, memo has to be prepared, family has to be informed, right to legal recourse has to be given. So this also comes from article number 20, no self-incrimination. Then article 22, within 24 hours you need to go to magistrate. Okay, magistrate has to issue the custody. The custody can be judicial custody, magistrate can give a judicial custody, where the person would be lodged in jail. Jail comes under state government, or it is under the list 2 of schedule 7, or the person can go to police custody where the investigation has to take place, but that custody should not exceed 15 days. Usually CRPC says that the police custody should not exceed 15 days. So over here, now court has come up with a stricter view with regard to the bail pleas of police personnel accused in custodial death cases. So what we have seen, that there were a lot of custodial deaths where the police has misused their power in the custody, misused their power on the person in their custody. Most of the times the police have killed them, and that is why here the court is very strict with regard to the bail of the police officers who have been booked under custodial death. You need to have a stringent law on custodial death. Otherwise, what has happened, the police has been misusing their power. As we know, police has the power to oppress, police has power to use violence. So this is where this power has been misused by a lot of police officers, and that is why the court has come tough that you need to stringent the laws which will book the police who is responsible, police officer who is responsible for custodial death. In DK Basu case also, the court also highlighted the same concern that we need to have a thorough medical check. A medical check has to be done before going to the police station and after releasing from the custody, so that we can match the person has not been given any torture. Torture has become very common with regard to the police custody. Torture is illegal and unconstitutional under Article 21 clause 3. Why? Because under Article 21 clause 3 you have right against self-incrimination. Police cannot beat you, police cannot torture you to give evidences. It is the duty of the police to investigate, collect your samples, collect blood samples, semen samples, and then conduct the investigation. So police cannot beat anyone and ask anyone to confess their offense. Okay, so this is also against United Nations Convention against Torture, though India has not ratified that, because if we would ratify United Nations Convention against Torture, then we also have to do away with our capital punishment. Okay, death sentence we have to remove. So that is why India has not ratified it. Now, custodial death takes place when the person is in the custody and either directly or indirectly significantly attributable to activities. This we have already discussed. You can just go through this slide. I'll be uploading this slide on Telegram. Custody refers to the protection, care and guardianship of individual. Custody is a positive connotation. When someone has given me custody, so that means I am duty bound to protect that. When an accused is under police custody or convict under the jail custody, so there the authorities are duty bound to protect him. So this is where the protectors are become the killers. This is what court has been saying. This should not happen. There should not be any case regarding this. Okay. Now another thing is, every arrest is custody, but not every custody is held for arrest. Problem is, there can be a statement every arrest is custody, but not every custody is arrest. Many times the police take a person into custody because police has to ask certain question. Investigation is going on. Police will call you, keep you in the police station and make you sit there for at least 5, 6, 7, 8 long hours. That is also custody. You have not been arrested yet, but you are into custody. So that is, every custody is not arrest, but every arrest is custody. Now every arrest is custody. Obviously, arrest involves taking a person into custody by legal authority. Arrest means by legal authority where police has done a diary entry, a diary note has been made, Panchnama has been filed, FIR has been lodged, the person has been taken to judicial magistrate. Now judicial magistrate has asked the police to keep the person in the police custody so that investigation can happen, trial can begin, charge sheet can be made. So this is where arrest involves a legal custody. So arrest always implies custody. That means a person's liberty has been restrained. If a person has been arrested, he has been arrested as per the procedure established by law and he cannot claim Article 21. Clear? But every custody is not arrest. Every custody is not arrest means custody can exist without a formal arrest. A person has been called to police station and has been made to sit there for 10 hours and the police is not allowing him to leave the police station. Custody, not arrest. There also police is responsible to protect him. At the same time, children in conflict with law may be taken into protective custody, not arrest. Under certain laws like preventive detention, a person may be held without a formal arrest, that is called as nazarband. Without a warrant, the person can be kept in the police station or the person can be kept within their home, again a kind of custody. So custody can exist without formal arrest. Now another term which has come up, that bail procedure should be made stringent with regard to the police officers who have been accused of custodial death. Now as we know, bail is a norm and jail should be exception in most of the cases, because we follow the idea of the restorative as well as the rehabilitative form of justice. We don't follow the idea of the retributive. Our idea is more with regard to reformative system. So we try to believe that jail should be exception and bail should be norm. In most of the cases, bail should be given, jail should be an exception. But over here, jail should be the norm and bail should be the exception. This is what court is trying to tell us. Now, what is bail? Bail is nothing but a legal mechanism that allows an accused person as a temporary release. He can be temporary release. Bail is a statutory provision. It is not the matter of right. Court has already said in Narayan Sai case that bail is not your right. You can ask for bail as per the provisions given under BNNS currently, but it is up to the judicial magistrate whether they want to award you bail or not, and it also depends upon the crime you have committed. Now, it upholds the principle of innocent until proven guilty. So obviously when the person has been arrested, the trial is going on, charge sheet is yet to be filed. Till the time the person is not convicted, you are presumed innocent because you are yet to be proven guilty. So the first instance the law will presume for you is that you are innocent, you are not guilty as of now. So this is where you can see that it is there to ensure a balance between the right of individual as well as interest of justice. Let us see, a person has been arrested, taken into custody, he can go for a bail provision. If the matter he is involved into is not very stringent, court can ask his release on a bail bond, where a person would be asked to come to the court or police station as and when required. So this is where a person's liberty has been protected as well as justice at large would be served. Now when it comes to bail, there are different kinds of bail. Regular bail, a person who has already been arrested or in custody, during investigation or trial, he can go for a regular bail. He can go to court and ask for a regular bail. My trial is going on, it will take time, or I just need to be out on bail because I haven't committed any serious crime and I won't be committing that crime again. On this particular bail bond, surety bond, a person would be released. Second is anticipatory bail. That is usually for the matter which are considered with non-bailable offences, where you know bail would be impossible once you are arrested. So in that scenario, you can go in a preemptive manner, pre-arrest. Before the person is arrested, person can directly approach to the court and ask for anticipatory bail. In that scenario, person would not be arrested. Interim bail, let us say temporary bail, the decision is pending, the charge sheet is yet to be filed, charge sheet or the anticipatory bail is pending. Let us say a person has applied for regular anticipatory bail, he can immediately seek an interim bail. Usually court issues an interim bail and later stage they give either the regular or the preemptive bail, anticipatory bail. Next is the default bail. Default bail is usually when the police is unable to file the charge sheet within the 90 days of arrest. In that scenario, the person can visit the court and ask for a default bail. Because the trial is yet to be started, investigation agency has failed to file a charge sheet, and hence the person can move to the court for securing a statutory or default bail. So these are the bail provisions. The next is Patna High Court strikes down 65% quota in Bihar. So recently overturned Bihar's 65% quota. As you know, that court has time and again said in Indira Sani case also that in any scenario the reservation should not breach 50% limit. So after implementing EWS quota, reservation went up to 75%, where the court has said no, this is not allowed. It should not be allowed because there are no extraordinary circumstances. Okay. So in no extraordinary circumstances, you can increase the reservation above 50%. And this is where the concept of sub-classification also comes. Currently government is looking for sub-classification for OBC. There was a committee, Justice G. Rohini committee, which was constituted to give sub-classification of OBC. What is sub-classification? Sub-classification means among OBC, they would be divided into various parts or various groups. The forward OBCs, the backward OBCs, the most backward OBCs, and depending upon their population, equity, the reservation would be distributed to them. Let us say over here you have let us say you have around, within OBC there is a group of OBC. Now A group has 20% population. Out of the total OBC they have 20% population. So out of the total seats, let us say total seats are 100. I am just giving example. So they would be asked to contest on 20 seats, fight on 20 seats. So this is what is called sub-categorization. Now the government report is yet to come out that how they are going to do OBC for the how they are going to do sub-categorization for OBC. Because when it comes to OBC, the court believes that OBC are heterogeneous community. Heterogeneous means they are different from each other. One is forward, one is highly better off, one is very backward, one is most backward, one is high economically backward, one is socially backward. So there are different criteria of backwardness among OBC, and that is why this sub-categorization has to be done. More backward will get equitable benefits, less backward will get equitable benefits. Now, up till now, the court was saying that SCs and STs do not require the sub-categorization because they are homogeneous community. But now the court has changed. In 2004, in Chennaiya case, court has said that SCs and STs do not require the sub-categorization because they are considered as homogeneous class. But in 2023, the Davinder Singh case, the court has said that 24 January, the court has said that sub-categorization of SCs and STs has to be done. It is required because this will ensure substantive equality. Supreme Court of India ruled that state cannot alter scheduled caste list published under Article 341 of the Constitution. They cannot alter. So what state can do? State cannot change or add the name in the scheduled caste list. SC list can only be changed by the central government on the recommendation of governor or president himself. Okay, so president might change it if the governor asks him to do so or president feels. So OBC list can be prepared by center and state. SC/ST list can be only prepared by center. Now, what is substantive equality? Substantive equality is like should be treated alike. In India, we follow more of substantive equality and less of formal equality. Formal equality is equality before law. Substantive equality is equal protection of law. Okay. Like should be treated alike. Next, state is free to identify different degrees of backwardness, provide special provisions such as to achieve specific degree of harm identified. Depending upon what backwardness do they have, state can add population in OBC, but state cannot add in SCs and STs. Here, state has to send the names to the NCSC and NCST. Okay, this we have already discussed. Sub-categorization, this news we have already discussed. Right to be silent. Right to be silent comes from Article 20 clause 3, right against self-incrimination. If you could recall Nandini Satpathy case, court also said that right to remain silent is a fundamental right during arrest under 20 clause 3 of the constitution. This is right against self-incrimination. If police arrest you, you want to remain silent, you can say, I will not speak anything, let my legal recourse come. Or my legal recourse would be filing the response from my side in the court. I'll not reply your questions. So this is right to remain silent during police questioning. This was recently in news due to Arvind Kejriwal's arrest. Fine. So this is a right under 20 clause 3. What other rights you have under 20 clause 3? Right against self-incrimination. The person has right from brain mapping. Court has held in Selby case, brain mapping, narco test, polygraph. These are unconstitutional tests and cannot be done unless the permission of court is sought. So you have to take the permission of district court. Once the district court gives the permission, only then police can do these tests. This happened last in Aftab case. So brain mapping, narco analysis, polygraph are also held unconstitutional under Article 23. So these tests, or the person is protected from these tests under Article 23. But it also has exceptions. Something which is allowed. What is allowed? Allowed is your samples, collection of evidences, collection of your hard drive, hard disk, computer, handwriting sample, blood sample, semen sample, DNA sample, anything which is required for scientific investigation. Police can collect it. You cannot deny it. You cannot ask that it is a protection. Whereas right to remain silent and these many things are protection under Article 20 clause 3. Fine. This we have. It is available to accused. Those who have been accused. What is accused? Accused is a person who has been arrested or who is under custody because police believe that the person has done some wrong or he is under suspicion. So accused means that trial is going on. So accused is always innocent. Whereas when the court convict the accused or when the court finds yes, the person was involved in crime and court gives in punishment, he becomes convict. So accused has all the rights under Article 20. Clause 3. Yes, there is exception as well. So if under Customs Act, FEMA Act, this also has protection. The person being questioned under this does not have protection. So when you are under the smuggling laws, when you are under the FEMA laws, you cannot say that my 20 clause 3 allows me not to speak. Here you have to speak. Okay. So because you are not considered as an accused. Now, Maneka Gandhi case, if you could recall Maneka Gandhi case, 1978, court came up with a golden triangle rule. What is golden triangle? Golden triangle means the law of parliament should not infringe Article 14, Article 19 and Article 21 of the Constitution. So, and this case also gave the concept of due process of law. Due process of law was also propounded by this case. Now, what is due process of law? Due process of law says that if parliament make any law, the law of the parliament should not infringe the golden triangle. If it infringes the golden triangle, the law can be held invalid. This is due process of law. While making the law, the due process, what is the due process? Not compromising someone's 14, 19 and 21 is due process. Next comes minority rights. Now, minority rights, as you know, December 18 annually, it emphasizes on the protection of the minorities. Term minority is not defined in the Constitution. What exactly is minority? Minority are usually under Article 29 given through three major propositions that a person is a minority if the person has distinct language, distinct script or distinct culture. Under Article 29, the person is deemed to be minority. Whereas under Article 30, linguistic and religious minority is given. Linguistic minority depending upon the language speaking people and religious minority is given by National Commission for Minority. Okay, so that gives us the status of minority. So minority refers to the group differing in religion, language, ethnicity, culture from the majority population. Indian constitution uses the term but does not explicitly define it. Supreme Court has consistently said that minorities should be identified at state level. So let us say in Punjab, Hindus are minority. So the benefits to the minorities under Article 30 while establishing the institutions. Article 30 says that the minorities have right to establish educational institutions. So these minorities would be identified on the basis of the state population. In Punjab, the Hindus are minority, so they can establish a minority institution within Punjab. This is what is called as. Same goes with Northeast and Jammu and Kashmir. Minority rights are given. Currently, we have 6 minority communities officially recognized. Muslims, Christians, Sikh, Buddhists, Parsis and Jains were added in 2014. It is given by the National Commission for Minorities. 29 clause 1 grants minority right to conserve their language, script, culture. 30 provides religious and linguistic minorities to establish and administer the educational institution of their own choice. At the same time, 30 clause 2 prohibits the state from discriminating while giving grants in the minority institutions. Let us say if the state starts giving grants to one minority institution, it should give this to everyone. You cannot say we will not give it to the Parsis or will not give it to the Christians. If you are giving to Parsis, Christians can also claim that. The state shall not discriminate with the minorities. So these are the rights given to the minorities. Also, we have just discussed Article 29 is available to the citizens. Now 350A, 350B, it is about the primary education and recruiting a special officer for linguistic minorities. Fine. Now these are the national bodies and their objectives. National Minority Development Finance Corporation, it gives financial assistance to minority. Maulana Azad Educational Foundation, develop education among minority communities in higher education. State Minority Commission, grievances of the minority communities at state level. Then you have Waqf Board to manage the properties, ensure the utilization of the properties and the assets in the favor of Muslim community. What if Waqf? Waqf is nothing but charity. Anything which has been given to Waqf under charity will be used for the charitable purpose for the Muslim religion. And anything occupied by Waqf cannot be sold, cannot be transferred to someone else. And that is where the government is coming up, Parliament is coming up with a bill to reform this board. Now, right to privacy. Right to privacy is again in news. Why in news? Because the Election Commission wants that Aadhaar and election card should be linked and voluntary. And if you do not want your Aadhaar card to be linked with your election card, you have to go to the Election Commission office and give a representation that why your card should not be linked. And that is why there is discussion going on in newspapers in the Election Commission. So Supreme Court observed that privacy is integral to individuals' dignity. So privacy is an important right. Fine. Right to privacy is an important right. From this very right, another right was in news, that is right to be forgotten. Right to be forgotten. A right to be forgotten is an important right in European Union under general data privacy rules, data protection rules. But in India, it is not a established right as of now, but though Delhi High Court has given us right to be forgotten. Right to be forgotten means that if you want all of your digital assets, all of your videos, your content should be deleted from all the platforms, you can invoke this right and ask the court to get it deleted. So Google and all the search engines, all the websites, YouTube, everyone will delete your videos, your content, whatsoever content you want to get deleted. So that means you want that the internet should forget you, that the online media should forget you. This is right to be forgotten, not well established. Earlier the government was implementing this right through the data protection bill, but now data protection bill of 2023 does not has any such instance. So currently this right is, yes, the High Court has said it is a right under Article 21, but High Court of Delhi has said this. High Court of the Supreme Court of India is yet to give any call on this. So currently we can presume, yes, under Article 21, right to be forgotten is a right, came out of right to privacy. It is the right under the umbrella right of privacy. So privacy has become an umbrella right. Umbrella means the major right. From this umbrella right, various other rights will emerge over the time. Okay. Now over here, the court has held that restriction on privacy. If the government of the state want to restrict the privacy of anyone, it should have three fundamentals. Number one is legislative mandate. The law should be passed by the parliament as per the procedure. Next is the purpose, legitimate purpose should be there. Let us say the government in the current income tax bill 2025 has said that we are free to keep a surveillance on your digital media if we think or we believe or the income tax department believe the person has siphoned off the tax liabilities. So in that scenario, it's a legitimate concern. So court has said legislative mandate, legitimate state purpose. Legislative mandate means law says that legitimate state purpose, state wants taxes are necessary and people are evading their taxes. And proportionality means the restriction upon the person. What is proportionality over here? That let us say if a person is not paying the taxes and you are hampering his right to privacy, then the proportion has been done because the person has absolved or not given the tax, so the government can use this law. But if a person is rightfully paying the taxes, he is not under any kind of surveillance, he is not under any kind of crime or hasn't done any crime, then also government is doing a surveillance upon that person, that is against the proportionality. So proportionality means the nature and the extent of the restrictions must be necessary in a democratic society. Proportionality means, let us say I am a teacher, I speak bad about government, my voice or my privacy cannot be hampered just because I have criticized the government. Okay, criticism, bad is criticism. But yes, if I'm unnecessarily creating a lot of crisis, I'm unnecessarily asking people to stand against the state, I'm doing the sedition or something like this, then obviously my right can be curved, privacy can be removed. So proportionality means depending upon what I have done, the proportionate response should be generated by the government. That is called as doctrine of proportionality. Proportionality is used in so many cases to balance the law of the parliament and the right of the citizen. So if the law of the parliament or the right of the citizen has to be in proportion to each other. If you have to infringe fundamental right, or a person has done something wrong, then proportionate force has to be used over here. Just because someone has said something, criticized the government, you cannot throw him in jail. It is just disproportionate response of the government. Next, state right to acquire private property. There was a long battle between the state and the people with regard to the acquisition of property. Earlier, you know, property was a fundamental right under Article 91F. It was made a limited right by very first amendment. It was deleted as a fundamental right by 44th amendment. Currently, it exists as a constitutional and a statutory right. Constitution says that your property would be saved or the property would be regulated as per the laws. Laws are made by the state because land is a state subject. Now, court delivered a judgment regarding the interpretation of Article 39B of the Constitution. 39B is a socialist principle of the Constitution which says that no non-concentration of wealth. Wealth should not be concentrated in the hands of few. Wealth should be used for the public purpose. But here court is saying that redistribution of material resources for the common good has to be done as per the adequate procedure. Now in this case, all private properties cannot be the part of material resource of the community. My home cannot be part of this material resource. Obviously, if I have land, forest, I have agricultural land, I have pond within my land, that is material resource. My personal space, my home is not a material resource. So this is where the court was trying to again strike a proportion between the right to acquire or the duty to acquire for the development of the nation, whereas vis-a-vis right to my property. So if my property is of personal use, obviously it should not be acquired, but if it is of general use, material resources there, then it can be acquired. So ownership and control of material resources of a community are so distributed as to best subserve the common good. But what exactly is material resource? So court said that material resource means the resource which is not in personal use. Personal assets like house, vehicles could not be classified as resource for community because they are privately owned. Whereas resources that may qualify this definition of community is forest, ponds, mines, minerals, even if it is privately held. Let us say I have a land. Tomorrow, under my land, I found a gold mine. Okay, in that scenario, the parliament, the court can, the authority can take that land. But I just have a land. It is of no material resource. It is just for my personal use. There is no resource, mine, mineral over there. So this is where you can see that only those resources can be taken up which are for the public use. Now, can everyone's property be acquired? This we have discussed. No. What is 19(1)(f)? This we have already discussed. Current status, you have a constitutional right under Article 300A. Then there are case laws where Supreme Court has said that material resources of community to include all the national wealth, whether private or public. This was held in 1977, but now the court is saying the scenario has changed. The public property or the property for public use should not be the property of personal use, like home or the land belonging to personal use, self-use cannot be considered as a material resource. This is where we have to draw a line. Next comes the personalities right of celebrities. You can see that people have been using personalities, voice, their style, their accent, their way of acting, and that has become very famous. And this is where the personalities have came up to protect their right as their names, their voice, the way they speak for the profit purpose. So this is renowned personality should register their names so that they can safeguard their personality rights, and misleading advertisements cannot be taken up. Like the way Amitabh Bachchan, the way Jackie Shroff says, so that cannot be used for by any other person for the profit purpose. That means, let us say I'm a mimicry artist, I am doing mimicry and I'm doing that for profit purpose, or I'm using that particular accent for my advertisement. So that is a profit purpose. I cannot do that. Why? Because celebrities can be registered, their voices, their way as a trademark for commercial use. So 19(1)(a), freedom of speech and expression, and Article 21, both of them give the personality rights to these individuals. Otherwise, we have certain statutory provisions as well. Copyright Act of 57. It also says that the authors, the performers, the actors, singers, musicians and dancers have the right. These rights include receiving credit for their work. Let us say if I am using that particular way of delivering some advertisement, I'm doing that for my profit purpose, I have to pay the royalty fee to Jackie Shroff or Amitabh Bachchan, whatsoever voice I am using. Then obviously the Trademark Act also protects this the personals under section section 14, which restricts the use of personal names and representation. So Trademark Act is there, Copyright Act is there. These acts are there to protect these personalities from misuse of their voice, from misuse of their accent, misuse of their personality. That is what is called as a personality test. Now, in Auto Shankar case, court also held that person's right to control the commercial use of one's identity is protected. So, if my identity is being used for commercial purpose, I can protect it, or I can take the royalty under this. Next comes the right to free food. Now, what is right to free food? Right to free food was basically discussed on the World Food Day, that where food happens to be an important aspect of life. Without food, no one can sustain. So there has to be food security as well as the nutritional security. It ensures that there should be unrestricted access to the food. There should be unrestricted access to the culturally appropriated food. Right to feed doesn't mean that I just have food to eat. Food should be of my cultural choice. Food should be according to my daily needs. Nutritional value is also required. So this is again a legal right recognized by Universal Declaration of Human Rights. UDHR gives it as a legal right, and the United Nations, the International Covenant on Economic, Social and Cultural Rights, also gives the right to food as a international right or a human right. Now, three elements: it should be available, it should be adequate, it should be accessible. This is how right to food has been given. In Article 21 of the Indian Constitution, Supreme Court also says that right to food also comprises of or it is also part of right to life under Article 21. PUCL case 2001, right to food is a fundamental right under Article 21 of the Constitution. So next is right to form trade unions in India. Recently what has happened, Samsung industry workers have come up with a right, they have demanded that they should be allowed to form the trade unions. Technically speaking, trade unions is or form associations is a fundamental right under Article 19(1)(c). 1C says that you have right to form associations, union or cooperative societies. The term cooperative societies was added by 97th Amendment 2011. It is also a fundamental right. But over here, the associations are subject to the laws of the state or the industrial laws. Let us say Parliament has passed some industrial law, and in that industrial law, the state government has said that unionism is not allowed. You cannot form unions over here. So this right is also restricted because its restriction comes from public order, morality or sovereignty. So ultimately, public order is there. Let us say if the state feels that such kind of unionism should be against the public order or they are immoral in nature. Let us say tomorrow sex workers want to have a association, so that would be considered immoral as of now. So and plus something is against sovereignty. So these kinds of associations are not allowed because they are a threat to the nation. So that is why 19(1)(c) has restrictions from 19 clause 4th. Now 43A was added by Indira Gandhi. That was 42nd Amendment 1996. This amendment included that you have the state shall endeavor that unionism can be promoted. So this is where that mandates the state to take measures that promote workers' participation in the management of industries, encouraging the growth of cooperative society. This was basically a socialist aspect because in the socialist setup, you have unionism as an important way of the management of workers in the industries. Under unionism, the industries and the workers of the industries and the owners of the industries, they sit together, they discuss the policies for workers. They sit together and discuss the rights of the workers. Workers gets due advantage over here. So that is why this duty was created. Similarly, 43B was also added by 97th Amendment, which talks about that state shall endeavor to make cooperatives in the system. Now comes what kind of associations are valid or what kind of associations are not valid. Now, when it comes to association which goes for collective bargaining and strikes, strike is not a fundamental right. Bandh are the rights, but they can be regulated. Coercive bandh, coercive bans are not allowed. Coercive bandh means coercive lockouts. Let us say tomorrow you say a union comes up and say we want to close the market. If I want to open the market, if I want to open my shop, I'll not be coerced to close my shop. So collective bargaining and strikes, the right to form trade unions does not automatically guarantee effective collective bargaining. That doesn't mean that tomorrow you'll declare a lockout, you'll declare a complete bunk of the industry. Every worker will say, I'll not go to industry, or the union will not allow anyone to go to factory, or they will force the workers not to go to factories. That shall not be allowed. You don't want to attend the factory, okay, the union can stop doing that, but forcing is not allowed. So bargaining or the right to strike is not allowed. These are regulated by Industrial Dispute and Trade Unions Act of 1926. At the same time, the fundamental right is also recognized through ILO, International Labour Organization Declaration of Fundamental Principles of Right at Work, says that okay, you can come up with the associations, but those associations should not be coercive in nature. Then recognition. Forming an association does not grant the right to union recognition. Doesn't mean that you have formed an particular association, you are looking for a recognition and you are forcing the state to recognize you under any act. That is actually not allowed at all. Then comes the rival unions. These right to form an association does not include the right to inform or interfere with rival unions. This is again not allowed, that such kind of associations are not allowed which will force you to set up a rival union. So rival unionism is also not allowed at all. That means some association is there and you want to start your association as a rival association, rival union. That is also not a right. So I guess this is all for the day. Whatsoever fundamental rights were in news, we have thoroughly discussed that. I have tried to link them with the static section as well. So in the next video, I'll be coming up with more current affairs of the rest and the remaining part of the polity. Till then, goodbye, take care, and God bless you all.